Okay, everyone, welcome to today's AAM webinar. It's Angie Sana, Manager Client Solutions of Alliance for Audited Media in Canada, and it's my pleasure to welcome you to applying the 5 types of consent under CASL. Before we get started, a couple of housekeeping notes. Our presentation today is 60 minutes, and we have allotted time for a question and answer period. All webinar attendees are on mute. Please enter your questions in the question box on the bottom right of your screen. We encourage you to enter your questions throughout the session. The session is being recorded and will be sent to you in the next few days. Leading today's webinar is Derek Lackey, a marketing and branding specialist and CASL guru. He is the managing partner of Newport Thompson and president of the Direct Marketing Association of Canada and a recognized CASL expert. Derek has been involved with the Canadian anti-spam legislation since the beginning. He has conducted numerous educational sessions and helped Canadian and U.S. organizations become CASL compliant. Derek is author of the first, and only, I think, book on CASL not written by a lawyer, CASL Compliance, A Marketer's Guide to Email Marketing to Canadians. AAM has teamed up with Derek to share our expertise and offer an educational approach to help organizations become fully compliant with the law. We are delighted that you joined today's session and welcome your questions at any time. Just enter them in the question box on the bottom right of your screen. Over to you, Derek.
Thank you, Angie. Well, welcome everybody. I put some links up here in case any of you are interested in any of these sites, including the book. Anybody who on the call who would like a copy of it, just send me an email and I would be happy to give you a complimentary link. So let's go right into it. What we're seeing around the world is an awful lot of regulations coming out. And I believe that the more we use data for marketing, the more regulations we're going to have to deal with. So the newest one to come up online, we all thought CASL was pretty stringent, and GDPR makes it look like a cakewalk. So I don't know how many of you have looked into GDPR if you do any European business, but it is far, far tougher than CASL to comply with. It literally changes the way you think about collecting data and using it. So heads up on that one. We'll be doing a lot more webinars on GDPR. We are confidently getting up to speed and working with several clients, so we will keep you posted on it. But for now, let's talk about CASL compliance. There's really two ways to deal with CASL. CASL stands for the Canadian Anti-Spam Legislation, for those of you who don't know. And really what it limits is it limits who you can send email to and how you send that email. In essence, it's a combination of opt-in and consent-based regime. And it's one of the first in the world to go to an opt-in based regime. But there's two ways to deal with it. You could do this stay out of trouble program, we call it, and that really is just prove consent for every individual that you have on your list. Send all emails with prescribed info, and make sure you include a working unsubscribe in every email you send. And that goes, one of the often mistaken perceptions of CASL is that it's just for bulk email. It is not. It is for all email, one-to-one, as well as bulk. So email that a salesperson sends to a prospect without consent is now illegal. So I'll repeat that. It's bulk email as well as one-to-one. So again, when we get into compliance programs with clients, they think at the beginning that we're only doing bulk. But it turns out we must deal with the one-to-one because that's the area that most of us are going to get in trouble with. I say to most of our clients that if you're going to get in trouble with CRTC, it's likely going to be your salespeople causing that. Then on the other side, we have a get out of trouble program. So the CRTC has defined what a compliance program looks like, and it covers these points fundamentally. You appoint a chief compliance officer. You must design processes and practices to comply with the law. You must create an electronic messaging policies and procedures manual. Again, no manual, no compliance program. Include your consumer complaint process, include your internal discipline process, and train your staff. And the get out of trouble means that you can claim a due diligence defense, so that if a mistake is made, an honest mistake, you can claim a due diligence defense and likely get off with a warning, a letter of warning, rather than a fine. But without the compliance process in place, even an accident, even a legitimate, oops, we made a mistake, if you're just doing the stay out of trouble program, you're likely going to get fined for the mistake. So we advise most of our clients that it really is worth the little. You do 90% of the work when you develop a stay out of trouble program. You do 90% of the work. You may as well do the other 10% that gets you a get out of jail free card. So the biggest issue in CASL is absolutely the ability to prove. You have to prove everything to CRTC. They don't accept your word for anything, and mainly because it's not fair to everybody in the marketplace. If one brand says, "Oh no, yeah, we have consent for all of our lists," and can't prove it, it's not fair to anybody if they accept that for one group and not for another. So they felt the easiest way to do this was to say that everybody has to provide proof. And the proof doesn't stop at consent. The proof also, when you get an order to produce by CRTC, it includes all the email you sent. For example, they'll outline it, but they'll say, show us all the email you sent and to who for the last 6 months. So you have to be able to easily recover that kind of data. So in order to obviously recover it, to prove, you have to set systems up to be able to easily do that. So what we do with our clients is we look at their current systems and create a gap report and start to change the things that we have to change one by one and bring them into compliance. So this is what we mean by a compliant program. So you really start with the email audit, you move into the design phase of the program, you document it, you put the technology in place to be able to do proper record keeping, and then you train the staff. So that's what a compliant program looks like. So I'll go through each step just briefly. And if anybody has any questions, please fill out the form, the questions form, and Angie will interrupt with questions as we go through rather than saving them till the end. So if anything occurs to you, don't hesitate to jump in and ask the question. So the 5 stages, the first one, we start with a comprehensive examination of your organization's existing electronic messaging program. And then, using as many of your current practices as possible, we design your compliant processes. We then document the entire organization's email, SMS, text policies and practices in your electronic messaging policies and procedures manual. That, by the way, is a living, breathing document. You should always consider that it's not one and done and put on the shelf. As the CRTC further puts out explanations and interpretations of how they're going to enforce this law, we may call our clients and say, the interpretation that we took was incorrect, and we need to correct that in your policies and procedures manual and send a note out to staff. Consent must be tracked so you can prove it. Changes in real-time data need new technologies to help track changes. So, for a lot of us who have legacy systems in place to manage our data and our email marketing, we really need to rethink it. The best we've seen without fail across the board is that the marketing automation combined with CRM. If you combine those two technologies, and there's lots of programs out there that combine both, you can pretty much mark consent on every individual file. You can track dates. You can set suppression dates. If nothing changes, the email clock runs out in 2 years, that email should be suppressed. And you can automate all these and set triggers. So by far, we're finding that the marketing automation and CRM tools combined make for pretty good automation to be able to track real-time changes in data and consent. And your staff must be trained in your electronic messaging practices. This is very important. We don't train staff in CASL because nobody cares. We train them in what our electronic messaging practices are, the little processes that we develop in order to bring a client into compliance. That's what the staff needs to be trained in. And then they must understand their role in the compliance process. So if there's accountabilities for example, salespeople, there's certain things that salespeople need to do on their day-to-day basis to help the company comply. And we make those roles and responsibilities very clear in the staff training.
Derek, if you wouldn't mind,
Yeah.
we just had a question that came in. Thank you. The question was wondering if you have any recommendations on best marketing automation and CRM tools to use.
Yeah, we do. We actually are in the process of publishing a current white paper on that. So watch on the Alliance website and your email, and we will update you. We're almost complete on it, and we've done it. We did one last summer, and I'm shocked at how much it's changed. So the recommendations we would have given you last August are very different by this October. So we do plan to update that and let you know.
Derek, another 2 follow-up questions, basically looking for low-cost options.
Yeah, we always consider cost because we know that none of us have unlimited budgets and can just throw money at this stuff. So we're constantly, for example, HubSpot can do what we're talking about, but it's so expensive for most companies that unless they're using HubSpot for multiple other purposes, it doesn't make sense to put it in place just for CASL compliance. So HubSpot wouldn't even make our automation list, even though it can functionally do it. It won't make based on price. I think the average account on HubSpot is starts at like $2,500, and most of us are just not looking at solutions. We can buy a SharpSpring account for a few $100 a month, and it becomes your email service provider at the same time. So that's a consideration in any automation recommendations we make to clients. And we don't do the support and we don't sell it ourselves. We intentionally stay out of that space. There are experts in it, but we will often recommend combinations of packages. And oftentimes it's based on what you already use and what systems are in place for you already. So that's a consideration. So if you're already using Salesforce, adding their, I think it's Marketo is theirs, is easy. I'll talk more about that as we go through. What was the other question, Angie? I'm sorry.
No problem. You've actually addressed it. We had a couple coming in looking for low-cost options. For a small business, several $100s is still a little too much. So just really looking for an economic and feasible solution.
Yeah, I don't think you're going to get away with record keeping for much less than $500 a month. But that will include your email marketing, your email sending as well. So it'd be your emails, and that's SharpSpring. SharpSpring's based in Gainesville, Florida. We've been using them for about a year. But it only gives you your bulk solution. You still have to, we operated for the first year of compliance. We've operated with a manual unsubscribed system, but it worked. Because, the reality on our one-to-one emails is if you get an unsubscribe once every 6 months on the one-to-one, I'll be surprised, but unfortunately, you do have to have that in place. It is part of compliance. So let's take a look and let's talk for a few minutes about choosing consent styles. So under CASL, there's 5 different forms of consent, and we're going to walk through each one of them. But as we walk through them, you can start to map on which ones are going to best suit your company. So CASL allows you to select the type of consent for your compliance programs, but while Express is obviously the best, sometimes, like I know some of the big banks that I know the chief compliance officers, and they've gone to email customers only. So they've gone to strictly an implied consent as your existing business relationship. And they don't email prospects, and they don't even offer express consent. They just email to existing clients. They use all sorts of other techniques to reach prospects and non-clients. But for email, they've decided that implied consent is going to be their strategy. So again, you need to look at, what choices are best based on your organization, your industry practices, and the way you do business and how you're structured currently. We like to try to make as little change to an organization as we can, and yet still bring them into compliance. Apologize, I have my phone on in the background and it's decided to get active. Let's go into the 5 types of consent. So we have obviously express consent. I'll get into a little more detail on each one of these, but express consent is basically somebody willingly and knowingly giving you permission to send you certain types of email. There is specific language, and again, I will give you the details of what language is used in order to claim express consent. Biggest problem I'm seeing with clients is their web forms do not use the proper language. So I doubt that if ever audited and they claim express consent because they think they've been collecting express consent, I believe the CRTC will say that is not express consent because it was not collected using the proper language and proper what's called prescribed information. So again, I'll walk through that when we talk about express consent. Implied consent in existing business relationships is really for customers and near customers. And there is a 6-month allowance for inquiries. So anybody who expresses interest in your company in any way, ask for brochures, download a white paper, sign up for a webinar. So everybody on this call or everybody who registered for this webinar can be added to our list for 6 months with an unsubscribe in every email. And if after 6 months you haven't engaged with us in a more meaningful way, we must suppress you. We must remove you from our email list. Or if you unsubscribe during that 6-month process. And then we have existing non-business relationship, which is really for charities. So the number 2 existing business relationship is about businesses, whereas existing non-business relationship is really for charities, associations, clubs, not-for-profit. And it's fundamentally the same as existing business relationship, but they are enforcing it with a lot less rigor. And there is a blanket if you are sending an email that is just about donations, just about gathering donations, then CASL doesn't apply. So there's some nuances within the existing non-business relationship that are a little back to the old opt-out basis like the US currently operates with. CAN-SPAM is an opt-out system. CASL is an opt-in system. The third type of implied consent is rather controversial. We call it the B2B clause. And basically, it's if you've publicly displayed your address, or if you've been referred by somebody, there is some implied consent that goes with that. So again, I'll get into more details with you as to what those measures are. And then personal relationship consent. Now, you know, personal relationship is probably not going to apply to 99% of our business emails, because, you know, the last time I checked, we don't send grandma emails. So let's look at express consent. People who take a positive action willingly and clearly sign up to receive emails. So, you know, in this model, no pre-checked checkboxes. So we used to be able to default to a check box and have people uncheck it if they didn't want it. Can't do that under CASL. So we need to see a positive action on behalf of the person signing up. So sometimes the positive action could be as simple as filling out, if the only purpose they're filling out the form is to be added to your list, that's a positive action. But if they're signing up to a webinar and then separately they want to subscribe to your newsletter list, then you need to give them an unchecked checkbox with the proper language. And the sender must approve date and timestamp along with IP address. So if 90% of your list is entered by you from the same IP address, you're not going to have legitimate consent and proof of consent in CRTC's mind. I think if you make phone calls and you enter them into, you get their permission verbally and you enter them in and you have a few like that, I don't think there's going to be any eyebrows raised. But if the bulk of your list is you entering, you are going to have trouble. So I promised what to include in your opt-in language. So company name and mailing address, and this is prescribed. So if any of these 4 elements are missing in your paragraph, your opt-in paragraph, you're likely not going to be accepted as express consent. So company name and mailing address, a description of the messages, the kinds of messages you intend to send. You need to add a contact name and 2 ways to reach that person. We generally use phone and email. And then you need to state that you can unsubscribe at any time. So what that looks like, here is a compliant web form. So we're asking for first name, last name, email, and we're giving them room to say something if they wish. And yes, please send me information on data privacy and email compliance in Canada, Europe, and USA from Newport Thompson. There's our address. I can reach your chief privacy officer at this and this phone number, and I know I can unsubscribe at any time. Don't need the checkbox because all they're doing is signing up for email, but we added it as overkill, and then we've put CAPTCHA in to prevent the robots. Here's one from Direct Marketing News in the US, who is not compliant with CASL. Nor should they be, because they operate predominantly in the US, but you cannot do this any longer. This is sufficient for an opt-out society, but not for an opt-in. So, you know, thanks for choosing DM News. What CASL is asking us to do is be completely transparent about who we are, how to reach us, and what we're going to send them. And if we do that, we're legitimate. So hopefully that's clear to everybody. If you have any questions, please fire them. Oftentimes people have specific circumstances that they would like to ask a question about. And I included this not to walk through it, but to provide it for you in the follow-up. You'll all get a copy of this PowerPoint. And I thought that these slides from CRTC themselves would give you a pretty good little summary of what each one are, how long you have to keep the records, time limitations, etc. All right.
Okay, Derek, if you don't mind, we've actually had a
Yep.
slew of questions coming in, so and really fantastic. So let's start off. If our client signs a document that the addresses we have been supplied with have been collected in a way that is compliant with CASL, are we free and clear from sending out messages on their behalf?
I would say no. You could still be held accountable. CRTC could fine both of you. And then you would have to work it out with that supplier that they signed an agreement saying that you claimed you had consent and didn't, therefore it cost us, therefore we're trying to recover the costs from you. But it becomes private or private sector litigation at that point. CRTC will, and same for GDPR, they really do look at the data controller, the sender in this case. The sender's ultimately responsible. So if you send something to a list that you have questions on, you're accountable. So hopefully that answers that question. What's next?
Okay. Give me just 1 second. We had one more come in.
Sure.
Okay, contact name and 2 ways to reach. We are a media company, so there are not specific literal people that are appropriate for all opt-ins. You showed Chief Privacy Officer, which is a title and not a person's name. I have heard this now both ways. Does it have to be an individual human, or is it a department, or title really sufficient?
Title is more than sufficient, but it must be manned. So you can't just give your front desk reception so that somebody gets bounced around and is given a third degree. So you should be putting a direct line to somebody who can do something about. So typically somebody off of an email that's calling with a complaint, they need to reach somebody who can do something about it. That's what you got to put in there. So you got to make sure, in our case, the Chief Privacy Officer, that is being managed by an individual and monitored every day.
One last one. Are there any education level or other requirements for being assigned as Chief Compliance Officer in the eyes of CRTC?
Not at this time. And again, unlike GDPR, GDPR is having a requirement that your data processing officer, DPO, they're calling it there in Europe, must have certification. In Canada, to this point, there is no such certification, but it is expected that the Chief Compliance Officer has read the law and has put compliance processes in place. But formal education, no, we have not seen anything at all.
Okay, and one more. How can we get the IP address without an expensive automation system?
Anytime they fill out a form, your form capture tool should give you a date and time and IP address where it was filled out from. That's not expensive technology. That's probably every form that I've ever seen has that in the background. So I wouldn't expect. I would expect CRTC to call that fundamental.
Okay, great. And then we have one other question, but we're going to wait till you get to our number 2 type of consent.
Good cue.
Great.
So implied consent, existing business relationship, means that it's a customer or near customers. And by near customer, they define it as those you have sent a proposal to. So if you've engaged somebody like to the point where they've asked for a proposal, or that you've seen it, that you're at that stage of sending somebody a proposal, then they would fall under the existing business relationship. And that consent is valid for 2 years and rolls. So if you send somebody a proposal today and then nothing happens, but 9 months later they recircle and ask you for another proposal, a more up-to-date pricing or different circumstances, their clock starts again. Their 2-year clock starts again. Same with purchases. If somebody's on a monthly purchase program or on a 2-year subscription program, then you literally have the period. So a lot of publications do a 3-year subscription. So you have that 3 years that it's an actual subscriber because they're a customer, and then you have 2 years following from the date they no longer become a subscriber. You still have 2 years to try to win them back. But at the end of that 5-year period, you must set a clock that suppresses them if they haven't done anything else. So again, that's where the marketing automation and the CRM come into play, because you can set fields and you can set triggers and automations that if this happens, then change this. And you can do it fairly easily. And we actually have just found a couple of marketing automations that have hardwired CASL consent levels and dates right into it. So that will be included in our automation report that we do. What we call a light touch is the consent is valid for 6 months. And a light touch is something like send me sales literature, download a white paper, sign up for a webinar, some form of expression of interest. We call that a light touch, and your consent is for 6 months. So basically, if somebody gets in touch with you, they're doing their homework, you've got 6 months to move them towards a existing business relationship, 2-year consent. And if you haven't been successful at the end of the 6 months, you really should suppress them, because you now have your consent has run out. And during that time, it's very fair to ask them for express consent or any other type of consent during that 6 months. And that's generally what we recommend to our clients, is as soon as you get the light touch, the 6-month consent, do your best during that 6-month period to convert them to express consent, and then you don't have to worry about the changes to their relationship other than unsubscribe. So,
and that's great, Derek. Thank you, because the question was to please describe engagement in a more meaningful way. So I think you did cover that, but please keep the questions coming in. They are great.
Okay. This is an important piece on the web forms. If your form has multiple uses, create 2 separate transactions. So we used to use downloading a white paper to capture somebody's email ad. That was a list building strategy for most of us. That's not allowed under CASL. So when somebody's signing up for a white paper, all that means is they're signing up for a white paper. Doesn't mean you can start to email blast them. So you have to ask separately. So we're suggesting that you treat it as 2 separate transactions. So one, you capture all the data and everything for signing up for the webinar or downloading the white paper, and then secondarily underneath, with a separate checkbox on the proper language, ask for consent to add them to your email list. What we're finding is about half of the people who sign up for a webinar will also add themselves to the list because they're interested in the topic. And if you're not providing them good information on the topic, they'll unsubscribe. So but it's a lot more grown up kind of way to do it. What we're trying to do with CASL is give the power of the inbox back to the individual who owns it. For some reason, as marketers, we took ownership of people's inbox, and we really had no right to, and we just asserted ourselves on them, and there was no data protection. So the reason we have CASL is Campaign Monitor reports 180 billion spam emails every single day. That's staggering. So we can talk about well, it's just one email to one person, but when it becomes 1 million people sending one email to one person, it becomes overwhelming. And that's what's happened is we've ganged up on the consumer, and the laws, the governments felt that the consumer needed some protection. And not just us. Australia has a strict program in place now, as does Europe, as does Canada. The U.S. is currently, the CAN-SPAM Act is under, actually, I'm going to change my wording. The rules around CAN-SPAM are under review right now. So built into the CAN-SPAM law was a 10-year review, and that's taking place currently. So that they're not reviewing the act itself. That takes an act from Congress, but they are reviewing the rules around the CAN-SPAM law. And I think that in that process, they may be recommending to Congress or to some of the people to actually create a full review of the act itself. Because I think as long as we maintain an opt-out regime, spam is going to happen, and spam is defined as unwanted email. So if by just getting hold of my email address that you think you can have at it at me, while it doesn't break the law in the States, it will in many other countries. So you've got to be cognizant of who the emails are targeted to.
Derek, we actually had
Yeah.
a couple there, so I'm going to start reading them out. Implied existing business relationship. Is there a definition of what can be sent in the email under this definition? The content must be about the business relationship, or can it be any content?
That's a great question. So we clearly define what a commercial electronic email is, but CRTC has recently clearly stated that they expect transactional emails to also have an unsubscribe, a working unsubscribe. So we recommend to our clients treat everything like it's a commercial electronic message, and then there's like it puts you above the fray. So treat every email that goes out from your company as a commercial electronic email and put an unsubscribe in it and have all the prescribed information in the footer and be safe.
Okay. What is the best way to remain CASL compliant while managing several clients' emails as a marketing agency? What's the best way to make sure each client is CASL compliant with the list they provide us?
I guess the best you can do is understand clearly the web forms and how they're collecting them. It's illegal in Canada to buy lists now because of the consent. It goes without saying that when somebody sells you a list, they don't have consent for you to send stuff. So even if people signed up knowingly, you still really can't buy lists here. There's one exception. The Toronto Star has something called the Wonder List, which people sign up for good deals, coupons, and sweepstakes. And as long as you're sending them a good deal, a coupon, or a sweepstake offer, you're coloring with inside the line so you can rent that list. But that's the only exception I've seen. Buying lists is out. Under opt-in regime, you must build lists, not buy them. So I hope that answered the question.
Would consent to email for a white paper cover emailing the person the white paper, or are we talking additional non-transactional email unrelated to the white paper they requested?
Yeah, we are. It's full consent. From the moment they request the white paper, you've got full consent to send them. I would suggest that if they download a paper about human resources, that you don't send them marketing related information or something about IT, because that's not their space. So I would suggest that you kind of look at their role and make sure that the kinds of messages you're sending them are relevant to their role. But other than that, you can send them pretty much anything inside that 6 months in an effort to get either express consent or convert them to a customer or a full-on 2-year permission.
Okay, great. And
so in other words, I just want to be clear. As a result of signing up for this webinar, we can send you information about CASL broadly. We don't just have to send you information about this presentation.
Okay. Two more before we move on to the next slide. What about
Sure.
chat? What about chat bots? For example, Facebook bots.
Actually, the only part of social media that applies to CASL is the one-to-one communication. Everything else, posting on walls and all of the other things wonderful things that Facebook does, has nothing to do with CASL. CASL is only concerned when you have a personal address at risk. So your personal address inside Messenger, for example, or your direct messaging with Twitter, that would fall under CASL. But any broad stuff that you're just posting to your wall, that's not covered under CASL. I hope that answered that question.
This is like DM with Twitter.
Sorry?
Okay. Sorry, could you just expand on that a little bit more? A bot is a
Yeah,
one-to-one communication. This is like DM with Twitter.
yeah. DM with Twitter is included under CASL. So CASL applies to email marketing, SMS text, and one-to-one social media messaging. It hasn't been dealt with clearly by the CRTC at this stage, and the reason is there hasn't been much abuse of it. So as abuse of it goes up, CRTC will cover it. They have promised us some clarification and some instructions about how they're going to enforce in the social media area. They've been really weak on it, and they've admitted it. So stay tuned for that. But fundamentally right now, posting on the wall, so public broadcasting is fine. One-to-one messaging is not.
Okay. One last question before we switch over slides. Please, Derek, thank you. If we include consent, receive email, and other electronic communications under the e-Sign Act in our terms of service, and our customers check a box indicating that they agree to our terms of service at sign up, is that sufficient to satisfy express consent under CASL?
Yes, as long as it's not buried in a bunch of legal terms and conditions, as long as it's called out and you're pretty comfortable that they saw that and they willingly and knowingly. If you try to bury it in 7 pages of privacy or terms and conditions, you know you're going to get called out on that. But as long as it's part of the contract and it's called out in an appropriate way so that people know they're giving consent, that would be acceptable. We have most of the publishing companies we work with, most of them have a subscription form, and we simply added the proper text and got express consent when they sign up for a subscription. Now we don't have to worry about the 2-year rotation and keeping track of it all. Because with express, it's for life or until they unsubscribe. Now the Europeans are going to be much harder. They're saying express consent's only valid for 2 years and you have to renew it. So you have to re-up every 2 years. So it's like subscribing every 2 years. And if you don't resubscribe, you must suppress them. So the Canadian version is much softer. Express consent is for life or until they unsubscribe. All right, let's talk about the controversial conspicuously published, the B2B clause. So here are the conditions that must be satisfied. You know their current role, and I'm actually going to change that you can prove their current role. So what we do when we build lists for clients is we go on LinkedIn and we find what their current title is today. We take a screen grab of that and we call that Derek Lackey 1. And then they publicly display their email address without restrictions. And what's meant by without restrictions is you're going to start seeing people where they publicly display their email address on a website, for example. If they have a statement saying this does not give you permission to add me to your email list or anything like that, that's a restriction. So you have to be able to prove that they publicly displayed their email address without restrictions. So a second screen grab is required. So if in some cases, like your business card, I can just take a photograph a JPEG of your business card, your role and your email address are publicly displayed without restrictions. And then all I got to do is make sure that the messages I'm sending to that list are relevant to their role. So if those three things line up, you're good. So what we do when we collect business cards at trade shows is instead of taking the 6-month route of light touch or mild expression of interest, we call that publicly displayed because we have their business card, which gives us their title along with their email address all in one spot. So if we just take a JPEG of that and store it, and what we recommend to our clients is that you name the JPEG, like in my case, it would be, the JPEG would be called Derek Lackey, and it would just be put in a proof of consent file. And then make a note on my CRM saying that my proof is in the proof of consent file. And I got on the list by conspicuously published. So again, I'll go over that again. So take new screen grabs every 2 years to ensure they're in the same role and their email is still on public display. This is our recommendation as a best practice. This is not written in the law. They're very vague on what time frame conspicuously publish entails. They were clear about express consent being for life or until you unsubscribe, but they weren't that clear on conspicuously published. And in all fairness, it was put in at the last minute just before it went into enforcement. This whole conspicuously published piece was added. So I think that they overlooked attaching a time frame to it. The law is under review right now, and they may well put a time frame on this one. We're suggesting to our clients that they kind of follow the existing business relationship and treat it as a 2-year consent, and then just check every 2 years if they're still in the same job, take a new screen grab, and if they're still publicly displaying without restrictions, take a new screen grab, update your proof, and keep them on your list. On the referral side, if you're referred, you can email the person once. Now, once is highlighted. So if Angie refers me to somebody, I can email that person once and ask for consent to carry on emailing them. So the purpose of the first email is to clearly request willing consent. If I'm unsuccessful in doing that with that one email, the communication clearly is that they're not interested. So you must stop emailing them. Doesn't mean you can't pick up the phone and call them. Doesn't mean you can't send them direct mail. Doesn't mean you can't advertise to them. But you have to stop emailing them. So then once you get consent, you're free to email at will, always with an unsubscribe, and store the proof. In reality, the toughest thing we're watching clients struggle with is the record keeping, without question. That's the #1 challenge in implementing CASL compliance. So personal relationship, again, it really isn't applicable, but you have to prove that you know the person on a face-to-face basis. So no social media friends. So if we're friends on Facebook, that doesn't give me permission to email you. Or if we're friends connected on LinkedIn, again, that doesn't give me permission to email you. I've been questioned, and my interpretation, based on pretty in-depth knowledge of the law and the enforcement bulletins, you can download it. I believe if you have a premium account with LinkedIn, you can download a CSV file of all of your contacts and their email address. And if you do that, and you now have a physical quote unquote directory that has their name, their role, and their email address all publicly displayed. So we're treating that not as a social media contact or friend or connection. We're treating that as a publicly displayed. So again, it's how you want to interpret and what kind of lists you want to build. So you have to also prove in personal that there is a two-way communication relationship now and in the past. And as I said at the opening of this, a few of us send grandma or cousins commercial electronic messages. So it kind of doesn't apply, but they had to include it to make sure that people realize that, you know, you can still email your family. Here's more detail again for you to absorb when you download the PowerPoint, and it gives the conditions of satisfaction for your proof if you're claiming personal relationship. It's tight. So one of the problems that they saw in the past with having any kind of opt-in is the anybody we ever met since we've been on the planet, we could call a friend, and they decided to be much tighter about personal relationship exemption in under CASL. So, email best practices. I'm going to suggest to you that if we thought about email marketing when it was first introduced, we would have asked permission to send promotional offers and info. We would have always allowed them to unsubscribe. We would be transparent and be really clear who's sending the message and on whose behalf. And we'd only send relevant messages, because otherwise they'd unsubscribe. And we wouldn't bombard them again, because they'll unsubscribe. So if you think of CASL, really, you know, the one way to look at it is it's the law and you got to do it. But the other way to look at it is, you know, if you're really taking care of your customers and doing email best practices, you would do all of this anyway. And that's really the bottom line message that we are spreading for as president of DMAC. We believe that this will save email marketing as an effective marketing tool. And left unchecked, it would have been a mess. It would have been a disaster. So we believe this is the right thing. We're heading in the right direction. But in a world where we were allowed to do whatever we wanted, and now we're being told we can't, there has been some resistance and some pushback. And you know, a lot of us are fairly far down the road of email marketing and been used to being able to do it freely, and now we're saying no. You know, the individual owns their email box, and you have to ask permission before you can engage with them in online.
Okay, great. We're coming up to the top of the hour, so if there are any more questions, please send them in and we'll try to address. Oh, wonderful. Okay, great. When selling a gift, a digital magazine, for example, can a giver of a gift provide the recipient email address that has consent to mail to? Or does the process need to be the giver notifies the receiver and the receiver needs to activate their gift in order to give consent?
Yeah, I would go with the latter, only because there is no, in the first one, there's no positive action on the receiver's side. So, you know, you could get away with it only if that first communication was about getting consent and having them click to validate their subscription. But I would err on the high side and always take the position that you know, the person, you know, probably doesn't want this unless they say it, unless they give you some indication that they would like this kind of information. Don't assume they would. At the very least, ask them. We have several publications who have an aggressive call center telemarketing program to verify past subscribers who haven't renewed and try to get them coming back on, but they're using phone to do it, not email. And then they're supporting it once they, during the telemarketing process, they actually confirm with a recording, they confirm consent, and they attach that recording to the database, and their proof is now built into the database. So it's all about setting up your little systems that work for you, that bring you into compliance. When they first brought this law out, I thought it was poorly written. The more I've worked with it in a variety of industries, with a variety of size of companies, I'm blown away by how flexible, how it allows you to be you and still be compliant. So you don't have to change the culture of your organization or the habits of your industry. You can include them in a CASL compliant strategy and still be compliant. Any others?
Yes, to be preventative to future rules and regulations, what should we be thinking about regarding all data collection, i.e. cookies?
Yeah, beautiful.
Yeah, it is a great question. Cookies, pixels, tracking how people interact with your website.
Yeah, well, if you take GDPR as the example, which is right now being heralded as the new high standard, get permission, get consent. So even cookies, don't make it a negative option. We're seeing even the sites that do have cookies. There's a notice that comes up that says, like it or not, we're collecting cookies. If you don't like it, don't peruse the site. I would suggest that for the consumers, the better approach is to allow yes, no. So allow choice within your cookies, and have technology that allows you, for an individual who doesn't want to be tracked, respect that. That's what all these new privacy laws and data laws are about, is respecting your prospect or consumer, and give them choice. And if given choice and they know that they know what kind of material you're going to send them and they like it, then great. You have a good relationship and your email will be very effective. A lot of us think that because we came from mass marketing, we think that email marketing is a numbers game. And I want to invite you to think of it not as a numbers game. It's not about how many email addresses you have on your list. It's about how engaged people are. How many, what's your open percentage and what's your click-through percentage? Those are the metrics that matter for email, not the number of email addresses you have. I'll give you an example. We had CRTC, the Direct Marketing Association, had them on a panel discussion in May here in Toronto. And I was given 3 weeks notice that they were coming. And I thought, okay, how am I going to do this? And I had a list of 143 people, I think, on a list of people at that time who wanted to know more about CASL. And I thought, well, what a great place to start. So I sent that 143 people one email, and I filled half of the 120 seats in that one email. So it's about quality, not quantity. Email is not a numbers game. Email is an engagement game. And those people, we had like a 70% open rate on that email, and we had 60 people literally register right away. So that's the power of email marketing, not blasting out PDFs of your flyer.
Okay, Derek, I think we have time for one last question. We've just topped the hour. What is the best way to audit existing email lists? Should any email with no proof of consent be automatically taken off any emailing list?
For Canadians, yes. So if you're knowingly targeting a Canadian and you cannot prove consent, it must be removed from your list. That was the change that happened on July 1st this year. They gave us a grace period of 3 years to clean up our list and to ground them every name and be sure we had proof for every name that we thought we had consent for. That period ended on July 1st. So up until July 1st, there was a little wiggle room that you could send those people emails to get consent. That's gone now. You cannot use email to get consent for email. And if you cannot prove, no kidding prove, how somebody got on your list and when, with like fly on the wall proof. So when CRTC comes in, you can actually show them where the person signed up, then you shouldn't be emailing them.
All right. Well, Derek, thank you so much for sharing your insights and expertise with us today. Thank you once again to all for taking the time to join us. I know everyone on this call understands just how critical it is that businesses be compliant with the law. If you'd like to stay up to date on CASL developments, receive tips from your colleagues working on CASL compliance, and to learn more about how AAM can help you achieve, please sign up for our newsletters at auditedmedia.com, follow us on Twitter or LinkedIn, and stay tuned for our next webinar in the new year. Don't hesitate to contact us directly. We look forward to hearing from you and would be happy to connect on a call to answer any specific questions you may have. Thank you again for your great questions and your participation. Have a great rest of the day.
Thank you, Angie. And I just want to put out to everybody that if you would like to get specific questions answered that apply to your organization, I am perfectly happy to set up a 1-hour call with you and your team and field any specific questions you have about your circumstances. And that is at no cost. And if anybody wants a copy of my book, please send me an email and I will give you a link. Have a great day, all.
Thank you.